I'm an innocent man, Your Honor, and I have always been an innocent man.
Y'all know that y'all convicted and had a wrong man in prison.
Case 1, John Bunn. The words crack through sobs. John Bunn stands before the judge, tears streaming down his face. His voice breaks with every syllable. 17 years of pain pouring out in one moment. The judge steps down from the bench, does something you almost never see in a courtroom, embraces him. This is the moment John Bunn's nightmare finally ended. But how did it begin? Let's go back to where it all started, to a 14-year-old kid who never saw it coming. John Bunn was 14 years old when they came for him. Just a kid, still in middle school. But Brooklyn detectives looked at him and saw a murderer. The year was 1991. An off-duty corrections officer had been killed during a carjacking. Police needed someone to blame. They found John and accused him of helping another teenager steal the officer's car. The case rested on one thing, a shaky eyewitness identification. No fingerprints, no physical evidence, nothing but someone pointing at a scared kid and saying, "That's him." John's conviction was part of a pattern. Detective Louis Scarcella built case after case using questionable tactics. Witnesses were coached, evidence was manipulated. People went to prison on his word alone. John Bunn was just one name on a long list of lives destroyed. For 17 years, John sat in prison. He had alibi witnesses. He insisted on his innocence, but parole boards kept denying him because he wouldn't admit guilt. They wanted him to confess to something he didn't do. Then Brooklyn's Conviction Integrity Unit started reviewing Scarcella's cases. What they found was damning. Coerced testimony, unreliable identifications, pure misconduct. In 2018, prosecutors stood before a judge and admitted the truth. John Bunn's conviction should never have happened. The judge agreed. After nearly 2 decades, the nightmare ended. When the ruling came down, John broke down in court. "They won't admit they framed me," he said through tears, "but God knows." The judge, who'd seen thousands of cases, stepped down and hugged him. A rare moment of humanity in a system that had shown John none. Today, John runs a Voice for the Unheard, a literacy foundation in New York. He mentors young people caught in the system. Kids who need someone who understands, someone who lived through the worst and came out fighting. John Bunn lost his childhood to a lie. He spent his teenage years and his 20s behind bars for a crime he didn't commit. But he didn't let that destroy him. He turned his pain into purpose. He's living proof that even when the system fails you, you don't have to fail yourself. Case 2. Kirk Bloodsworth. The door slammed shut behind Kirk Bloodsworth. 300 pounds of steel. The sound of his life ending. He was 23 years old, a former Marine, and Maryland had just sentenced him to die for a crime he didn't commit. July 1984. A 9-year-old girl named Dawn Hamilton disappeared into the woods. Hours later, they found her body. 2 young boys said they saw her with a tall, skinny man, 6'5", blonde hair, bushy mustache. Kirk Bloodsworth was 6 feet tall, red hair, over 200 pounds. He wore glasses. Nothing matched. It didn't matter. 5 witnesses swore they saw him. Anonymous tips flooded in. The prosecution called him a monster. His alibi? Ignored. Physical evidence? None. The jury wanted blood, and they got it. Death penalty. Case closed. But Kirk wouldn't accept it. From his 6x9 cell, he wrote letters, hundreds of them, to lawyers, journalists, anyone who would listen. "I didn't do this," he said over and over. The world kept turning. The executioner kept waiting. Then, in 1992, something changed. Kirk read about a case in England, a man freed because of DNA testing, a new technology, a chance. He pushed for testing on the evidence from Don's case. The state said it was destroyed. Kirk wouldn't stop. Finally, they found it. Semen-stained underwear in a paper bag in the judge's chambers. The tests came back. Kirk's DNA didn't match. June 1993. After 9 years, 2 on death row, Kirk Bloodsworth walked free. The first person in America ever exonerated from death row by DNA evidence. Years later, they ran the DNA through a database. It matched Kimberly Ruffner, a man Kirk had lifted weights with in prison. The real killer had been right there, saying nothing, while Kirk fought for his life. Today, Kirk Bloodsworth advocates against the death penalty worldwide. A federal program bearing his name helps fund DNA testing for prisoners fighting to prove their innocence. Maryland abolished the death penalty in 2013. Kirk was there when the governor signed it into law. Case 3. Central Park 5. April 19, 1989. Central Park. A white female jogger brutally assaulted. New York City exploded. The tabloids screamed for justice. Police grabbed 5 Black and Latino teenagers. Yusuf Salam, Antron McCray, Raymond Santana, Kevin Richardson, Corey Wise. Boys, children, and they decided these kids were guilty. The interrogations lasted hours. No lawyers. Some had no parents present. Detectives fed them details. Just tell us what happened. The boys, exhausted and terrified, repeated what the cops wanted to hear. The confessions were recorded. The city celebrated. Case closed. Except nothing fit. The DNA didn't match any of them. The stories contradicted each other. Forensic evidence? Basically non-existent. It didn't matter. The media had already convicted them. Donald Trump took out full-page ads calling for their execution. The trial was a formality. 4 were sentenced as juveniles. Corey Wise, tried as an adult, got the harshest punishment. He was 16 years old when the steel doors closed behind him. 13 years passed. Then, in 2002, a serial rapist named Matthias Reyes came forward. He confessed to the attack. His DNA matched the evidence perfectly. He knew details only the real attacker could know. The 5 boys, now men, had been innocent all along. The convictions were vacated. They walked free, but what they'd lost could never be returned. Childhoods, families, trust, years. The world started calling them the Exonerated 5. Netflix told their story in When They See Us. Millions watched. The outrage was global. Today, the Exonerated 5 speak worldwide about false confessions and racial injustice. Their case changed how America views coerced interrogations. New York City paid them $41 million in 2014, money that can never buy back what they lost. Case 4. Ronald Cotton, Burlington, North Carolina, 1984. A woman was raped in her home. Brutal, terrifying. She survived, and she was absolutely certain she knew who did it. Ronald Cotton, 22 years old. She picked him from a lineup. She pointed at him in court. "That's him," she said, her voice steady, her memory clear. The jury believed her. They sentenced Cotton to life plus 50 years. But Jennifer Thompson was wrong. Cotton had an alibi. The physical evidence was shaky at best. None of it mattered. Eyewitness testimony, especially from a confident victim, is powerful. Juries trust it. Judges rely on it. And it's wrong far more often than anyone wants to admit. Ronald Cotton screamed his innocence from his cell. He studied law books, filed appeals, refused to give up. Then DNA testing became available. Cotton pushed for it. The tests came back. He wasn't the rapist. The real attacker was Bobby Poole, a man who looked similar to Cotton. Poole eventually confessed. 1995, after 10 years in prison, Ronald Cotton walked free. In the courtroom that day, something extraordinary happened. Jennifer Thompson, the woman whose testimony put him away, was there. She approached him. They embraced. She sobbed. "I'm so sorry," she whispered. Cotton could have been bitter, angry, destroyed. Instead, he forgave her. They became allies, friends even. Together they wrote a book called Picking Cotton. Together, they fight to reform how eyewitness identification works. Today, Ronald Cotton travels the country speaking about wrongful convictions. He and Jennifer Thompson remain close, a testament to forgiveness and the human capacity for redemption. Their story has changed police lineup procedures across America. Case 5. Joyce Ann Brown, Dallas, Texas, 1980. Armed robbery. A woman dead. Police needed a suspect. They found a name, Joyce Ann Brown, a department store clerk. Wrong place, wrong name, wrong life. She had an alibi. She was at work. Didn't matter. Witnesses said the description matched. A getaway car was registered to Joyce Ann Brown, but not this Joyce Ann Brown. Another woman, same name. Police didn't care about details. They had their suspect. The trial was swift. Life sentence. Joyce Ann Brown, an innocent woman, disappeared into the Texas prison system. From her cell, she wrote letters, hundreds, thousands, to journalists, lawyers, advocacy groups. Most ignored her. Then 60 Minutes picked up her story. Centurion Ministries got involved. They dug deeper. The getaway car? Different Joyce Ann Brown. The witnesses? Unreliable. The real perpetrator? Still out there. The evidence of her innocence was overwhelming, but getting Texas to admit a mistake? Nearly impossible. The fight took years. Appeals, investigations, media pressure. Finally, the Texas Court of Criminal Appeals overturned her conviction. 1989. After 9 years behind bars, Joyce Ann Brown walked into the sunlight a free woman. National headlines. But the damage was done. 9 years stolen. Her life shattered. She didn't let it destroy her. She founded an organization to help other exonerees rebuild their lives. She became an advocate, a voice for the wrongly convicted. Today, Joyce Ann Brown passed away in 2015, but her legacy lives on. The organization she founded continues supporting women wrongfully imprisoned. Her case remains a stark reminder. The system doesn't just fail, it destroys lives. Case 6. Curtis Flowers, Winona, Mississippi, 1996. 4 people murdered in a furniture store. Curtis Flowers became the target. And for the next 23 years, the state of Mississippi tried to kill him. 6 trials, 6. Each time the same prosecutor. Each time systematically excluding black jurors. Each time, shaky evidence and inconsistent witnesses. And each time, except two, they convicted him. The physical evidence, weak. The eyewitness accounts, contradictory. But District Attorney Doug Evans was relentless. He wanted Curtis Flowers dead, and he would retry him as many times as it took. Flowers sat in prison while the wheels of injustice ground on. Then came the podcast In the Dark. Journalists investigated. They uncovered suppressed evidence. They exposed the prosecutor's tactics. They revealed the racial bias infecting every trial. The story went viral. Millions listened. The pressure built. In June 2019, the U.S. Supreme Court ruled unanimously. The jury selection violated Flowers' constitutional rights. Racial discrimination, pure and simple. But Mississippi still wouldn't let go. It took another year. Finally, in September 2020, the state dropped all charges. After 23 years, 6 trials, and 4 convictions, Curtis Flowers was free. Today, Curtis Flowers receives $50,000 per year for 10 years from Mississippi, compensation that doesn't come close to what he lost. He advocates for jury selection reform and prosecutorial accountability. His case exposed systemic racism in the American justice system. Case 7. Anthony Ray Hinton. Birmingham, Alabama, 1985. 2 restaurant managers shot dead. Police found a revolver in Anthony Ray Hinton's mother's closet. A ballistics expert said the bullets matched. That was enough. Death penalty. Anthony Ray Hinton was innocent. No eyewitness placed him at either crime scene. The ballistics evidence was questionable at best. His trial lawyer was inexperienced and underfunded. None of it mattered. Alabama wanted someone to die for these murders, and Hinton was convenient. He spent the next 3 decades in a 5x7 cell on death row, alone, in the dark, innocent. His mother believed in him. She visited. She prayed. She never gave up. Neither did Anthony. He read books. He befriended other inmates. He held on to hope when there was no logical reason to hope. Then came Brian Stevenson and the Equal Justice Initiative. They took his case. They brought in real ballistics experts, not the state's questionable witness. The new testing was clear. The bullets couldn't have come from Hinton's mother's revolver. Impossible. In 2014, the U.S. Supreme Court ruled unanimously. Hinton's trial lawyer was so ineffective, the conviction couldn't stand. Alabama fought it, but they couldn't win. Not anymore. April 3, 2015. After 29 years, 11 months, and 29 days on death row, Anthony Ray Hinton walked out of prison. He stepped into sunlight. He breathed free air. He had survived. Today, Anthony Ray Hinton works with the Equal Justice Initiative as a community educator. He wrote a New York Times best-selling memoir, The Sun Does Shine. He speaks worldwide about the death penalty. And he's still here, alive, despite the system's best efforts to kill an innocent man. Case 8, Clarence Brandley. Conroe, Texas, 1981. A white high school student visiting from another town was raped and murdered. Police needed a suspect. They found Clarence Brandley, a black janitor working at the school. Perfect. The investigation was a sham from the start. Physical evidence? A Caucasian pubic hair on the victim didn't match Brandley. Photos showing he didn't wear the alleged murder weapon belt? Ignored. An all-white jury? Check. Racially charged prosecution? Absolutely. Texas sentenced him to death. Clarence Brandley sat on death row for a crime he couldn't have committed. The evidence against him was falling apart. His lawyers fought. Appeals went nowhere. Texas was going to execute him. 8 years. That's how long it took for the truth to break through. Attorneys exposed prosecutorial misconduct. They revealed suppressed evidence. They proved the ballistics and forensics were faulty. Media attention grew. Advocacy groups rallied. Finally, the Texas Court of Criminal Appeals reversed the conviction, stating it lacked even the rudiments of fairness. January 23, 1990. Clarence Brandley walked out of prison after 9 years on death row. Free, but not whole. What Texas did to him couldn't be undone. He tried to rebuild his life, but the state that nearly killed him never properly compensated him, never truly apologized. Today, Clarence Brandley died on September 2, 2018, at age 66. He spent his final years speaking about wrongful convictions and racial injustice. Texas never gave him meaningful compensation for stealing a decade of his life. Case 9. Glenn Ford, Shreveport, Louisiana, 1984. A jeweler named Isidore Roseman murdered. No gun found, no clear motive. But police arrested Glenn Ford anyway. An all-white jury convicted him. Death sentence. Glenn Ford was innocent. Other suspects existed. His alibi checked out. But Louisiana wanted someone to die for this murder, and Ford, a black man, fit their narrative. He was sent to Angola State Penitentiary, death row, solitary confinement, and there he stayed for 30 years. 30 years. Think about that. 3 decades in a cell, alone, waiting to be executed for a crime you didn't commit. The world kept turning. Technology advanced. Presidents changed. And Glenn Ford waited in the dark. The prosecution knew they had problems. They suppressed evidence pointing to other suspects. They withheld exculpatory information. They built a case on sand and called it justice. In 2013, a confidential informant came forward. Others were involved. The case collapsed. In March 2014, a judge ordered Ford's unconditional release. Louisiana admitted he was innocent. March 11, 2014, Glenn Ford walked out of prison after serving one of the longest wrongful death row sentences in American history. He was free, but he was also dying. Lung cancer, stage 4. Louisiana had stolen 30 years of his life, and now his body was failing. He had months left. Today, Glenn Ford died on June 29, 2015, just over a year after his release. Louisiana never compensated him. Not a dollar. His case remains one of the most haunting examples of death penalty injustice in America. Case 10. Henry McCullum and Leon Brown, Red Springs, North Carolina, 1983. An 11-year-old girl named Sabrina Buey was found murdered. Police brought in 2 boys for questioning. Henry McCullum, 19, with intellectual disabilities, and his 15-year-old half-brother, Leon Brown. Hours of interrogation, no parents, no lawyers. 2 scared kids who didn't understand what was happening. The police fed them details, pressured them, broke them. Both boys confessed to a murder they didn't commit. Henry got death row, Leon got life. No physical evidence connected them to the crime. Their confessions were false, coerced from children who didn't know better. But North Carolina didn't care. 30 years. Henry McCollum spent 3 decades on death row, waiting to be executed for a crime he was innocent of. Leon spent 30 years behind bars, their lives stolen before they'd even begun. In 2014, DNA testing finally told the truth. Neither boy's DNA matched the crime scene. Instead, the DNA belonged to another man, someone police had dismissed decades earlier. The state moved to vacate the convictions. Media coverage exploded. How could this happen? How could North Carolina put children through this horror? Henry was released in September 2014, Leon in December. After more than 30 years, they were finally free. Today, both Henry McCollum and Leon Brown work on criminal justice reform, focusing on juvenile interrogations and false confessions. Their case changed how North Carolina handles young suspects, but it can't give them back what they lost, their entire adult lives. Case 11, Stephen Avery, Manitowoc County, Wisconsin, 1985. A woman named Penny Bjornson was attacked near a beach. She survived. She identified Stephen Avery as her attacker. He was convicted and sentenced to 32 years. Stephen Avery was innocent. The real attacker's DNA wasn't tested. Police had tunnel vision. They decided Avery was guilty and ignored everything that said otherwise. He spent 18 years in prison. In 2003, DNA testing proved he didn't do it. The real perpetrator was identified. Avery walked free. He filed a lawsuit against Manitowoc County for $36 million. He was about to become wealthy. Justice, finally. Then, in 2005, everything changed again. A woman named Teresa Haubach disappeared. Her car was found on Avery's property. Her remains discovered nearby. Avery was arrested and charged with her murder. The case became a media sensation. Netflix released Making a Murderer, a documentary questioning the investigation. Was Avery framed by the same department he was suing? Or was he actually guilty this time? The debate rages on. Supporters claim he was set up. Critics point to the evidence. The truth? Still unclear. Today, Stephen Avery remains in prison, convicted of Teresa Haubach's murder. His case continues to generate debate about police misconduct and wrongful convictions. Whether he was framed a second time, or whether he's actually guilty this time, that question remains unanswered. Case 12, Brian Banks, Long Beach, California, 2002. Brian Banks was 16 years old and a rising football star. Division I schools were recruiting him. The NFL seemed within reach. Then came the accusation. A female classmate claimed he dragged her into a stairwell and raped her. It wasn't true, but her word was enough. Brian faced trial. His lawyer advised him to take a plea deal, 5 years plus probation. "You're a big black teenager," they told him. "An all-white jury won't believe you." Innocent but terrified, Brian took the deal. His football career ended instantly. His scholarship disappeared. His future evaporated. He served 2 years in prison, then 5 more years on probation, a sex offender registry following him everywhere. But the accuser had lied. In 2010, she contacted Brian on Facebook. She admitted she made it up. He recorded the conversation. His attorneys reopened the case. 2012, The Los Angeles County Superior Court dismissed all charges. Brian Banks was exonerated. At 26 years old, he was finally free, but a decade of his life was gone. He tried for the NFL. Amazingly, he made it. He signed with the Atlanta Falcons, played for the Las Vegas Locomotives. A Hollywood ending? Not quite. The damage was done. Today, Brian Banks runs the Brian Banks Foundation, fighting for others falsely accused. He's a motivational speaker and justice reform advocate. His story was made into a film in 2019. He got his second chance, but it came far too late. Case 13, Anthony Porter. Chicago, 1983. Two teenagers shot dead on the South Side. Anthony Porter was arrested, convicted, and sent to death row. The evidence? Witness testimony that would later fall apart. Porter spent 17 years waiting to die. In 1998, his execution was scheduled. The date was set, the preparations made. He came within 50 hours of being killed by the state. Then, someone noticed Porter's IQ test. He had an intellectual disability. Illinois law prohibited executing people with such disabilities. The execution was stayed, not because of innocence, but because of a technicality. That delay saved his life. Northwestern University journalism students took up his case. They investigated. They found witnesses who'd been coerced. They uncovered evidence police had ignored. Then they found someone else, Al Story Simon, who confessed on video to the murders. November 18, 1999, Anthony Porter walked off death row. The case became legendary. A journalism class had done what the justice system couldn't. They'd saved an innocent man's life. Years later, the story got complicated. Simon recanted his confession, claiming a private investigator had coerced it. Was Porter actually innocent? Was Simon? Both? Neither? The truth became muddied. Today, Anthony Porter died on July 5, 2021. His case helped push Illinois to abolish the death penalty in 2011. Whether he was truly innocent remains debated, but one thing is certain. He came 50 hours away from execution, and the state would have killed him without ever knowing the full truth. Case 14, Robert Dubois, Tampa, Florida, 1983. A 12-year-old girl was raped and murdered. Robert Dubois was arrested. The case against him? An unreliable jailhouse informant and bite mark analysis. Junk science that's been discredited for decades. No physical evidence linked Dubois to the crime, but Florida convicted him anyway. Life sentence with no possibility of parole until he was in his 60s. He disappeared into the prison system. The world moved on. Dubois never stopped claiming innocence. From his cell, he filed appeal after appeal. They all failed. Decades passed. Technology advanced. DNA testing became standard. But Florida didn't retest his evidence. Why bother? He was already convicted. Finally, in 2019, the Innocence Project got involved. They pushed for DNA testing on the victim's clothing. The results came back. Dubois' DNA wasn't there. Instead, they found someone else's genetic profile. The state of Florida had imprisoned an innocent man for 37 years. March 18, 2020, Robert Dubois walked out of prison. 37 years stolen. He was 19 when they locked him up. He was 56 when he finally breathed free air. Today, Robert Dubois lives in Florida and receives state compensation. He speaks publicly about post-conviction DNA testing and the dangers of junk science in courtrooms. His case helped expose how many people remain imprisoned based on discredited forensic methods. Case 15, Marcellus Williams, St. Louis, Missouri, 1998. A journalist named Felicia Gale was murdered in her home. Marcellus Williams was arrested and charged. The evidence? 2 jailhouse snitches with incentives to lie. Questionable forensic testimony. No solid proof. Williams maintained his innocence. His lawyers argued the forensic evidence was shaky. Hair analysis, a method later discredited. Witness testimony from people making deals with prosecutors. Nothing concrete. Missouri didn't care. They sentenced him to death. Years passed. DNA testing advanced. Williams' attorneys pushed for testing on the murder weapon, a knife. The results excluded Williams. The DNA didn't match. Someone else's genetic material was on that knife. Missouri had the wrong man. In 2021, the governor granted clemency, commuting his sentence to life without parole. Williams was taken off death row, not freed, but alive. It seemed like a reprieve, a second chance. Then, in 2024, Missouri decided they wanted him dead anyway. Despite the DNA evidence, despite the questions about his guilt, they scheduled his execution. September 24, 2024, Marcellus Williams was executed by lethal injection. The DNA evidence that excluded him? Missouri ignored it. Witnesses who recanted? Didn't matter. The state killed him anyway. Today, Marcellus is dead, executed despite evidence of innocence. His case sparked international outrage. The Innocence Project, civil rights groups, even the victim's family begged Missouri to stop. They wouldn't listen. Missouri killed a man who may very well have been innocent. Case 16, Kevin Strickland, Kansas City, Missouri, 1978. A triple murder. 3 people shot dead. Kevin Strickland, 18 years old, was arrested. The case against him? One eyewitness, the only survivor, who later said she was wrong. Strickland was convicted and sentenced to life. 43 years. That's how long Kevin Strickland spent behind bars for a crime he didn't commit. The evidence against him was always weak. No physical evidence. His co-defendants said he wasn't there, but Missouri convicted him anyway, and then they refused to admit their mistake. Decades passed. The eyewitness recanted. She said police pressured her into identifying Strickland. Prosecutors who worked the original case admitted it was wrong. Evidence emerged showing Strickland couldn't have been at the scene. Missouri still wouldn't let him go. Finally, after years of legal battles and nationwide advocacy, Missouri's governor granted him a pardon. No compensation, no apology, just freedom. September 15th, 2021, Kevin Strickland walked out of prison at age 62. 43 years gone, more than half his life stolen. Missouri law said he wasn't entitled to compensation, a technicality based on how his conviction was overturned. The state that stole his life refused to pay him a cent. The public responded. A GoFundMe campaign raised over $1.5 million in 4 days. Today, Kevin Strickland lives free, but receives no state compensation. He works as a mentor for wrongfully convicted individuals. Missouri legislation is being reformed because of his case, but it came too late for him. Case 17, Randall Dale Adams, Dallas, Texas, 1976. A police officer named Robert Wood was shot dead during a traffic stop. The city wanted revenge. They arrested Randall Dale Adams, a drifter who'd been in the wrong place at the wrong time. The case against Adams was built on lies. The star witness? A teenager named David Harris, the actual killer, who made a deal with prosecutors to avoid death row himself. Harris testified against Adams. The jury believed him. Death sentence. Adams sat on death row knowing the truth. Harris killed Officer Wood, not him. But who believes a convicted cop killer over a teenage witness? Then came filmmaker Errol Morris. He made a documentary called The Thin Blue Line. It exposed the truth. It showed how prosecutors had coached witnesses, how they'd hidden evidence, how they'd let the real killer go free in exchange for false testimony against Adams. The documentary sparked outrage. Public pressure mounted. Courts reopened the case. David Harris, the teenager, eventually confessed on camera. He'd killed Robert Wood. Adams was innocent. 1989. After 12 years in prison, 4 on death row, Randall Dale Adams walked free. All charges dropped. Full exoneration. Harris? He was eventually executed in 2004 for a different murder. Today, Randall Dale Adams lived quietly until his death in 2010. His case remains a landmark in documentary filmmaking and legal ethics. The Thin Blue Line proved that media and film could expose injustice and save lives. Adams' story continues to be taught in journalism and law schools worldwide. Case 18. Clarence Elkins. In 1998, Clarence Elkins watched his life shatter. His mother-in-law was dead. His 6-year-old niece lay in a hospital bed, traumatized and broken, and police were pointing their fingers directly at him. The little girl's words sealed his fate. "He looked like Uncle Clarence," she whispered. That was enough. No fingerprints tied him to the scene. No blood evidence. No DNA match. Just the confused memories of a child who'd survived the unthinkable. Clarence got life in prison. But his wife Melinda refused to give up. While Clarence sat behind bars, she became a detective. She dug through files. She asked questions nobody wanted to answer. And she found a name: Earl Mann, a violent criminal, a registered sex offender, the neighbor next door. Mann lived right next to the crime scene. He had a history of attacking young girls. But police never looked his way. They'd made up their minds in hours, and Clarence paid the price. Then came an incredible twist of fate. Mann ended up in the same prison as Clarence. Same building, same cell block. Clarence saw his chance. He quietly collected a cigarette butt Mann had tossed aside and mailed it to his lawyers. The DNA matched. Mann was the killer. But even then, prosecutors wouldn't let Clarence go. Ohio's Attorney General had to hold a public press conference just to pressure them into doing the right thing. Finally, on December 15, 2005, after 6.5 years behind bars, Clarence walked free. In 2008, Earl Mann pleaded guilty. He confessed to the rape and murder. He got life without parole. Today, Clarence works to stop wrongful convictions. He helped pass Ohio's Innocence Protection Act, demanding better eyewitness procedures and DNA preservation. He gives back to the Innocence Project that saved him, funding scholarships for law students fighting similar battles. One cigarette butt. That's all it took to prove his innocence. But it shouldn't have taken that much. Case 19. Reuben Hurricane Carter. They called him Hurricane. Reuben Carter was a middleweight boxer with lightning fists and a reputation that filled arenas. In 1967, his life took a devastating turn. He was arrested for a triple murder in Paterson, New Jersey, a crime he didn't commit. The case against Carter was built on lies. Two criminals gave testimony after police promised them deals. There was zero physical evidence connecting Carter to the murders. No fingerprints, no weapon, no witnesses who could actually place him there. But prosecutors had something else: racism. They painted Carter as a dangerous black man. They used fear instead of facts. The jury believed them. Carter got 3 life sentences. His conviction was overturned once, but they tried him again. Same dirty tactics, same result. Carter went back to prison. That's when the world started paying attention. Bob Dylan wrote Hurricane, a song that told Carter's story to millions. Civil rights groups rallied. Lawyers dug deeper into the corrupt prosecution. The pressure kept building. Finally, in 1985, Judge H. Lee Sorokin had seen enough. He called out the prosecutors for their misconduct and racial bias. He vacated both convictions. After 19 years locked away, Reuben "Hurricane" Carter walked out a free man. They never retried him. The state knew they had nothing. Carter didn't waste his freedom. He founded Innocence International in Toronto, dedicating his life to helping others trapped by the same broken system. He became a voice for the voiceless, a fighter outside the ring who landed his most important punches. When Carter died in 2014, justice advocates around the world mourned, but his legacy lives on. Every year, organizations honor his memory. His foundation continues the work he started. The hurricane proved something crucial. You can't break a man who knows he's innocent. You can lock him up. You can steal his years, but you can't kill his spirit. Reuben Carter stood tall when everything tried to knock him down. That's the mark of a true fighter.
Case 20. Walter Ogrod. They called Walter Ogrod the Rivera Drive Monster. The name was meant to make people hate him, and it worked. In 1996, Ogrod was convicted of killing 4-year-old Barbara Jean Horn in Philadelphia. The community wanted justice. They got a man who had nothing to do with the crime. The case against Ogrod was built on quicksand. A confession obtained after 15 brutal hours of interrogation. Words that contradicted every forensic fact. 2 jailhouse informants who later proved to be liars, trading testimony for benefits. No physical evidence tied Ogrod to the little girl's death, but prosecutors hid evidence about other suspects. They buried facts that didn't fit their story, and they sent a sanitation worker to death row. For 23 years, Walter Ogrod sat in a cell waiting to die. 23 years knowing he was innocent. 23 years watching appeals get denied while the truth stayed buried. Then the Innocence Project got involved. They demanded DNA testing on the child's clothing. What they found changed everything. DNA from an unidentified man, not Ogrod. Someone else killed Barbara Jean Horn. Philadelphia's Conviction Integrity Unit reviewed the case. They saw the forced confession, the unreliable informants, the hidden evidence. They knew what they had to do. On June 5, 2020, prosecutors stood in court and admitted they were wrong. The district attorney publicly apologized. After more than 2 decades on death row, Walter Ogrod walked into sunlight as a free man. Today, Ogrod lives quietly in Pennsylvania. He works on prison reform, helping prevent what happened to him from happening to others. His case is studied in law schools as a textbook example of false confessions and prosecutorial misconduct. Walter Ogrod lost 23 years to lies. He came within months of execution for something he didn't do. The system almost killed an innocent man. He survived, but how many others didn't? How many people are sitting on death row right now, innocent but forgotten? Ogrod's story forces us to ask these hard questions. Because justice delayed isn't justice. It's just more suffering. Case 21. Ryan Ferguson. He was 20 years old when his best friend sent him to prison with a dream. Columbia, Missouri, 2005. A journalist named Kent Haytholt was murdered. Police had no leads, no suspects. The case was going cold. Then Charles Erickson came forward with a story that sounded impossible. He said he dreamed about killing Haytholt, and in that dream, Ryan Ferguson was there with him. That's all prosecutors needed. Never mind there was no physical evidence, no fingerprints at the scene, no DNA connecting either of them, no witnesses who saw Ryan anywhere near the crime. Just Erickson's fuzzy memories of a dream. 2 witnesses later admitted police pressured them to lie. But by then, Ryan was already behind bars, sentenced to 40 years. His father refused to accept it. He became his son's loudest advocate, appearing on shows, writing letters, demanding justice. Journalists started digging into the case. What they found was disturbing. Suppressed evidence, coerced testimony, and a prosecution built entirely on lies. The Midwest Innocence Project took on Ryan's case. They exposed the Brady violations, evidence prosecutors were legally required to share, but deliberately hid. They showed how the entire case rested on statements from people who later admitted they lied. In 2013, a Missouri appellate court had seen enough. They vacated Ryan's conviction. On November 12, 2013, after nearly 10 years in prison, Ryan Ferguson walked free. He was 20 when he went in, 29 when he came out. A decade of his life stolen by a dream testimony that should never have seen a courtroom. Today, Ryan lives in Denver. He works in fitness media and co-hosts a podcast about wrongful convictions. In 2020, he was awarded $11 million in civil damages, money that can never buy back lost time, but acknowledges the injustice done to him. Ryan's story exposes a terrifying truth. You can be convicted on the flimsiest evidence imaginable if prosecutors want it badly enough. Dreams aren't proof, but in Ryan's case, they were enough to destroy a life. Case 22. Joyce Watkins. He waited 40 years for 3 words. You were innocent. In 1988, she and her boyfriend Charlie Dunn were convicted of murdering her 4-year-old niece in Nashville. Prosecutors claimed sexual abuse and blunt force trauma. Flawed forensic testimony sealed their fate. Joyce got 27 years. Charlie got life. He died in prison in 2015, still labeled a child killer. He never lived to hear the truth. The forensic pathologists got it wrong. They misread injury timing. They testified to things that science couldn't support. Years later, modern forensics proved the child's injuries happened before the little girl was ever in Joyce and Charlie's care. It was physically impossible for them to have caused her death. But nobody listened for decades.
Joyce sat in prison, labeled one of the worst things you can call someone, a murderer of a child. Her family turned away. Society judged her, and she was innocent the entire time. The Tennessee Innocence Project finally reviewed the medical records. They brought in experts who looked at the actual science instead of guesswork. What they found was clear. The timeline prosecutors used at trial was medically impossible. Nashville's Conviction Review Unit joined the motion to vacate. In January 2022, the Tennessee Court of Criminal Appeals made it official. Joyce Watkins was exonerated. So was Charlie Dunn, though he'd been dead for 7 years. Joyce walked out at 77 years old, most of her life gone. No apology could bring back those decades. No settlement could return what was stolen. Today, Joyce lives quietly in Tennessee. She dedicates her time to faith outreach and helping women coming out of prison. She knows what it's like to be thrown away by the system. She knows how hard it is to rebuild when everyone has given up on you. Charlie never got his freedom. He died behind bars, innocent but forgotten. Joyce carries his memory with her, along with the weight of knowing justice came 40 years too late. Some wounds never heal. They just become part of who you are.
Case 23. Adnan Syed. In 1999, 17-year-old Adnan Syed was arrested for murdering his ex-girlfriend, Hae Min Lee. The prosecution's case seemed solid. Cell phone records, a friend's testimony claiming Syed confessed, and a jury ready to convict. Adnan got life plus 30 years. He was just a teenager. But the case was built on sand. The cell phone data prosecutors used to track his movements, experts later called it scientifically meaningless. The friend who testified against him, Jay Wilds, his story changed multiple times, riddled with contradictions nobody bothered to question. DNA from the victim's clothing? Never tested. Alibi witnesses who could prove Adnan was at school during the murder? His defense attorney never called them. Evidence that contradicted the prosecution's timeline? Hidden from the defense, buried in files where nobody would find it. For 15 years, Adnan Syed sat in prison while the world moved on. Then, in 2014, everything changed. A podcast called Serial told his story to millions of listeners. People started asking questions prosecutors never wanted to answer. The Baltimore State's attorney ordered new DNA testing in 2022. The results excluded Adnan completely. Investigators found alternative suspects police had ignored. Courts ruled prosecutors violated Brady laws by hiding evidence. On September 19, 2022, after 23 years behind bars, the Baltimore Circuit Court vacated Adnan's conviction. He walked out a free man. Maryland's appellate court confirmed his legal innocence in 2023. Today, Adnan works with juvenile justice nonprofits and studies criminal law. His case reshaped how people think about digital evidence and prosecutorial disclosure. Serial brought wrongful convictions into mainstream conversation, forcing millions to confront uncomfortable truths about the justice system. Adnan's story proves something powerful. Public attention matters. When people care enough to look deeper, when they demand answers instead of accepting easy narratives, the system has to respond. Sometimes justice needs an audience. Sometimes it takes a podcast to do what courts should have done decades ago. Adnan Syed lost 23 years, but his case may save countless others by forcing the system to do better. Case 24. Rodney Reed. He sat on death row for 25 years, watching execution dates come and go, knowing he was innocent. In 1998, Bastrop, Texas, Reed was convicted of murdering Stacy Stites. Prosecutors claimed DNA evidence proved his guilt. What they didn't tell the jury was that Reed and Stites were in a secret relationship. What they hid changed everything. The state's timeline was wrong from the start. They ignored witness testimony that contradicted their theory. They suppressed evidence about alternative suspects. Police corruption and racial bias infected every part of the trial. The DNA they said proved Reed's guilt. Modern testing showed it couldn't determine when it was deposited. It proved contact, not murder. But by then, Reed was already counting down to his execution. The Innocence Project fought for decades to get new evidence tested. National advocates rallied behind Reed as execution dates approached. Media attention grew. People demanded answers. How could Texas execute a man when so much evidence raised doubt? In 2023, the Texas Court of Criminal Appeals finally granted relief. They cited withheld exculpatory evidence and unreliable forensic methods. Reed's conviction was vacated. Prosecutors looked at what remained of their case and declined to retry him. After a quarter century on death row, Rodney Reed walked out in 2024. He came within weeks of execution multiple times. The needle almost stopped his heart while he waited for justice that moved at a crawl. He survived on hope while the clock counted down. Today, Reed works with innocence reform coalitions across Texas. His case prompted legislative proposals for mandatory DNA preservation in capital trials. When the stakes are life and death, the system can't afford to hide evidence or rush to judgment. Rodney Reed's story is a warning. How many innocent people have we executed because evidence came too late? How many more sit on death row right now, innocent but unheard? Some people get lucky. Rodney did. But luck shouldn't determine who lives and who dies. Case 25. Christine Bunch. She watched her 3-year-old son burn to death. Then, Indiana accused her of setting the fire that killed him. In 1996, prosecutors claimed Bunch used accelerants and deliberately trapped Tony inside their mobile home. She was convicted of arson and murder, sentenced to 60 years in prison. The evidence against her? Burn patterns and melted flooring that fire investigators claimed proved accelerant use. It was junk science, outdated methods that experts had already debunked. But the jury didn't know that. At trial, state fire investigators testified with absolute confidence. They pointed to scorch marks and said, "This proves arson." They looked at melted materials and declared, "This proves intent." None of it was true. Modern fire forensics experts later showed those same signs appear in accidental fires all the time. They're normal. They don't prove anything. But Christine Bunch was already serving 60 years by the time science caught up. The Indiana Innocence Project and Center on Wrongful Convictions reviewed her case. What they found was damning. State analysts had hidden test results that contradicted the arson theory. Chemical tests for accelerants came back negative, but prosecutors never told the defense. In 2012, the Court of Appeals vacated her conviction. They ruled that her entire trial rested on false expert testimony. On August 22, 2012, after 17 years behind bars, Christine Bunch walked free. She lost her son in a fire. Then she lost 17 years of her life to a system that convicted her using science that wasn't science at all. Today, Bunch runs Justice for Women, a nonprofit helping female exonerees rebuild their lives. She knows firsthand how hard it is to start over after prison steals everything. She knows what it's like when nobody believes you're innocent. Her case reshaped how arson evidence is evaluated nationwide.
Fire investigators learned they can't just make claims without proof. Courts learned to question experts who testify with certainty about things science doesn't support. Christine Bunch survived unspeakable tragedy twice, losing her son, then losing her freedom. She came out fighting. She turned grief into purpose. But no amount of advocacy brings Tony back or returns those 17 years. Some losses are permanent. All you can do is make sure they mean something. 25 cases, 25 lives destroyed. But these aren't the only stories. Right now, innocent people sit in cells across America. Some have been there for decades. Some will die there. Their cases haven't made headlines. They're waiting for someone to see what prosecutors missed or buried. Over 3,500 wrongful convictions documented since 1989, and those are only the ones we know about. Every case shares the same pattern: tunnel vision, buried evidence, false testimony, junk science. A system more interested in closing cases than finding truth. We're not done, not even close. These 25 cases are just the beginning. Hundreds more are waiting to be told. Subscribe, share these stories, because the more people who know how easily the system fails, the harder it becomes to hide mistakes. The next chapter is coming, and it's going to shake you even harder. This is Crime Lands, where every case reveals the cracks in a broken system. Question everything, because if it happened to them, it could happen to anyone.